supplementary cause list. Item number 1 for pronouncement of judgment.
Who's appearing for the other side? I'll read only the operative portion.
Yes, yes.
The learned counsel for the respondent has contended that the learned commercial code resorting to the provision of Order 21 Rule 26 CPC to pass the impugn order is well within its jurisdiction. So that was the contention, and this aspect of the matter is found acceptable to this court, inasmuch as since there is no specific provision in the Arbitration Act as regard execution of an arbitral award or the stay of the same. Therefore, the learned commercial code has committed no jurisdictional error in resorting to the provision of Order 21 Rule 26 to pass the operative portion of the impugned order. In view thereof, as pointed out above, the impugned order is found to have been passed within jurisdiction and the same is upheld, albeit with the modification of the same as regard the applicability of Section 82 to the proceedings. So this court has decided on 82, found that NIPCO is not a government per se. So it could be considered a state under Article 12, but not a government, to attract Section 82. But since the commercial court has taken resort to Order 21 Rule 26, that would be allowed. Thank you.
Your Lordship, I would like to mention.
Anytime next week, madam.
Who's for the petitioner?
From Guwahati TPS, madam.
Guwahati? Mr. Sangresu is here, isn't he?
Sangresu is not there anymore, madam.
Oh, he's not there anymore? Is he online?
Maybe Mr. D.K. Das is there.
Mr. D.K. Das.
Or else it will be called out, madam. Maybe it can be called out, madam.
Yeah, Mr. Das is there. Can't hear you. Unmute yourself.
Am I audible, Lord?
Yes, you are. So, you are in this case?
Yes, my Lord. I represent for the petitioner, my Lord.
So, accommodation has been sought for by the learned DSGI. Any objection?
My Lord, we have an objection, my Lord. For the past 2-3 dates, my Lord, we are not able that, my Lord. This matter was actually required to be heard, my Lord.
Yeah, required to be heard, actually.
Well, it's an old matter of 2016, my Lord. If my Lord allows, my Lord, can we place the facts of the matter, my Lord?
We will not go.
Online,
We will not go into.
Next week we will fix a date.
We will not go into piecemeal hearing. We'll fix.
Anytime next week, my Lord.
So we'll fix the day after 1 week then.
As my Lord is pleased, my Lord.
Or you,
if we have some offence in the matter, my Lord.
okay, so you tell, or you so you suggest a date.
My Lord. My Lord, next week, can it be on 10th, my Lord? If it's convenient to my Lord. Monday, my Lord.
Monday is the normal day. It can be done 12th, 13th, anytime. It is convenient to my friend.
Maybe, my Lord. Let it be on 12 or 13, my Lord. If my Lord is pleased, my Lord. If it's convenient to my Lord, my Lord.
Fine.
Let it be on 12 or 13, any date, if my Lord.
So we'll hear this matter on 13th then.
13th.
Lord, in that day, Lord, the endeavor may be made for Lord, final disposal of the matter.
As and when it is called up, if parties
Yes,
are ready, court will take up.
Yes, I'm grateful.
Accommodation has been sought for by the DSGI on the ground that he is not prepared to be heard in this matter today. Though the petitioner has raised initial objection to the preamble, however, it was considered that the matter may be allowed to be adjourned for the day, but to be heard definitely on the next date fix. As agreed to by the parties, list this matter on 13.
Highly obliged, my Lord.
Please, Lordship. Lordship, I beg to mention for item 6, Lordship.
6 2016 matter.
Yes, Lordship, and this matter is supposed to file an affidavit
Yes, that Home Guard matter.
Yes, Lordship. Regarding with the benefits, you have just received instruction from the Lordship client, so you bring for week's time, Lordship. You will be filing affidavit.
The counsel for the petitioner has submitted that the instruction from the petitioner has just been received, and as such it would take some time for the affidavit to be prepared, for which some time is sought for. As prayed for, this is matter after 2 weeks.
Please, Your Lordship. Lordship, I beg to mention item number 4, Your Lordship. Lordship, I pray that the matter may come up next week, Your Lordship. Senior counsel is out of station, Your Lordship.
This cannot be. Sorry. This matter has been time and again. I think even on the last occasion is made clear. I believe you must have. I don't know. Now you see, I've lost touch. Whether you have advanced argument on your part. I believe so.
Lordship, if you recollect, I had finished my argument.
You have?
I had finished my argument, and there was issue only of verification of record and the private respondent. And then after that, we have almost more than 6 months have lapsed. And I'm sure the court may have...
See, this is the problem. 6
months, I can imagine, Your Lordship. It's not possible that Lordship will recollect my argument. So we'll have to start fresh again.
What is required here? Is the matter to be heard, or is there any affidavit to be filed?
Lordship, they were supposed to verify the record. The time was given.
Oh, okay. Oh, yes, now I recall. You're supposed to go through the records, and that's all. And that's about it. Nothing else. So by now you must have, you must have gone through the records, surely.
Senior counsel is not here. Matter of only verification of records, but more than 6 months. I think so. We have to start again.
This is the problem.
We will not burden the court also by saying that I finished my hearing, because there was slightly issues of facts were involved.
Can you let
We'll fix the matter on 10th, and no more adjournment. Whether you are here or not, we'll hear the matter.
Lordship, maybe 11th or 12th, because 10th our matter is fixed, Lordship, but not linked on that.
It's fixed on 10th?
Yeah, that will take a lot of time.
So 11th?
11th.
Yet, once again, accommodation has been sought for on behalf of by the petitioner on the ground that the senior conducting counsel is out of station and is thus indisposed. It may be recalled that time and again this court has accommodated the parties in spite of the fact that the matter is a very long pending one. Though no strong objection has been raised by the respondent, it is incumbent upon this court to ensure that matters are heard when the same are called up. When the same is called up. in view of the submission made, the court would allow the prayer for adjournment. It is, however, made clear that this will be the last and final chance to the parties to be heard in this matter. Irrespective of as agreed to by the parties, this matter is now posted it's posted on 11th.
Will you oblige, Lordship?
On daily cost list, item number 1.
On the last date, this matter was heard on the condonation of delay.
Okay.
And
So what is
Malak
it
was
called?
pleased to ask me a judgment in support of that.
For that review thing,
Yes, ma'am.
whether the period of under review can be taken as
No, Malak.
Can be condoned, can be taken to be a sufficient ground for condoning the delay.
No, Malak, so far review is concerned, that portion, so far judgment is concerned, I could not exactly get of that. But so far review itself is concerned, the period of review, that itself constitutes a good ground for condonation, because that matter was sub judice before the court. So after subtracting that review period, the period comes to a nominal days of around 200 something.
or after the
Yes. So that 200 period. So to that effect, it's a judgment I've given from the Supreme Court. The matter ought to be decided on merit, and each case depends on the facts.
that of course, you see,
Yes.
that is well
Yes,
settled. You
that's
see. Every matter has to be decided
Yes,
on merit, but you also have to look into the conduct of the parties.
Yes, ma'am. So I have categorically explained my delay for all these periods, except that the delay, that was substantial delay, was caused because of the review. So under such circumstances, the condonation may be allowed, the matter heard on merit.
That, my lord,
Because there are
period consumed in disposal of the review, your lordship. There is no law which gives them a concession for the condonation. There is no law. Limitation Act does not speak that way, your lord.
But you see, Mr. Mansuri,
Lordship.
it's logical.
My lord,
When a matter is sub judice before a forum,
my lord.
how can further proceedings be conducted?
No, that has to be gone into it, my lord. Whether there was any review maintainable at that point of time. There was no review was not maintainable, my lord.
This court cannot sit in judgment over
Well, not the
merits of the.
Then the intention of the party is very clear, my lord. It was only intended to delay the payment of the award, because they had no grounds to go for review, yet they had gone. What does it shows, your lordship? It shows that they wanted to delay.
no, my lord, that is not
That intention is very clear. If there was no ground for review, why did you go for review?
Mr. Mansuri, you also have to consider this is a case of award of compensation.
My lord,
Now they are at the receiving end.
my lord,
If it is their intention to delay,
my lord.
and eventually you are found, to be entitled to the award, then what happens? You get the benefit of the interest, accrued interest.
That I admit, my lord. But then
So at the end of the day, you are not loser.
this matter, my lord, started since the year 2012, my lord.
True.
Almost 11 years. And when the time came to get the fruit of that judgment award, my lord, they filed a review which was practically not maintainable.
Mansuri, that is the fallacy of the system, which we cannot correct.
But that is true, my lord.
We can perhaps sugarcoat it to a certain extent, but nothing. It's a malice
correct
in the system. Whatever the case may be,
My lord. And
parties have to be given adequate opportunity to.
beyond that review also, my lord, the period which they have taken, that also may be taken into consideration, my lord. The files were moving from one place to another. There was a delay. There was a delay on the part of the council also. I have submitted a judgment to your lordship where it has been clearly mentioned that these are not sufficient ground for condoning the delay. And that too in MSc cases. So those judgments I have submitted, my lord.
well, I can pass this.
Have you filed your bullet points?
Well,
List. I mean your your gist of a submission in bullet points? Have you?
I've given in my in the that is it's at para 7 of mine.
The submission that you have made, relying on certain judgment, on what are the points raised in the oral ratio of the judgment, so on and so forth.
I've given that judgment, but basically this judgment.
That is, you have given the judgment now, the basis of the judgment on which you have relied. Rather, the gist of your argument, just to be given in bullet form, or the court is not asking for a elaborate written argument.
No.
But Mr. Masuri, you've done that.
I have given my show cause against there. And
that is a different thing.
All right. Based on that, my lord, because the facts are all there, my lord. I have taken all my stand in that objection.
And I have taken my stand in my petition. That can be perused. Para 7.
So I'll pass this orders then. If that is the case then.
Yes.
All right.
Counsel of the parties. Okay, I'll see if I'm able to do it today, I'll do it. If not, I'll post it for later.
Well, obliged.
Item number 2.
My lord, this is the matter, my lord, where the petitioner company had supplied pipes, my lord, to PH department.
This is your
482 application.
I also have to bring certain facts on record, so my objection will be necessary.
Facts, you see, if records are required to be called for, they will be called for. You can produce the record.
The state is here, state can produce the record, my lord, at the time.
Yes, state can produce the record. So why is it necessary for you to file a proper response?
Because in this matter, there are FIRs and counter FIRs. So the record may not indicate those things. So kindly allow me to file an affidavit. We already have protection from this honorable court. This is a matter of 3 weeks. I'll file my objection. I'll just bring those facts on it.
My lord, only one aspect,
my
lord, only before my friend starts, my lord. My lord, no courtship, that much protection has been given to us, my lord. My lord, what is happening? The directors of this company, my lord, lords, you've seen that this is a Jindal Group company, my lord. One director is in Delhi, one is in Calcutta, my lord. And they're elderly people, my lord. Now, the offences are bailable offences, my lord. One is 34, one is 120, so without any significance, my lord. The only substantive section is 469, my lord, which is a bailable section, my lord. Though cognizable, but bailable, my lord. Now, they are issuing notice after notice, my lord. We requested them to please allow us to appear online, my lord. I can place the medical documents of these people, my lord. And for this kind of offences, issuing successive 41A notices, my lord. So we have informed them that they are sick people, they are elderly people, are travelling from all the way from Delhi or Calcutta, may not be feasible at this time. And the matter is sub judice before this honourable court. In our submission, there is no reason for the Joy police, my lord, to investigate the case. As I pointed out on an earlier occasion, my lord, we have filed an FIR in Calcutta, my lord. Calcutta High Court on 12th April 23, my lord, this year, quashed that FIR, my lord. Taking advantage of that was quashed on 12th April, my lord. On 16th April, they come here, my lord, and file a counter blast FIR, my lord, in Joy, the other side. We go to Supreme Court, my lord. Supreme Court has set aside the High Court's order, so that investigation has been revived, my lord. So once in the same set of facts, my lord, when West Bengal Police is investigation and CID is investigating that matter, my lord, the crime branch, detective department of Calcutta, West Bengal Police, now, and that too on bailable kind of sections, my lord. Only 469 is the substantive section, 120B lords over 34 are only supplementary sections, my lord.
So let us, Mr. Shulai,
What happened, Your Lordship? What happened? An assurance has been given before this court that they will cooperate with the investigation. But suddenly, Your Lordship, under section 91 CRPC and so also under section 41A CRPC had been issued. What the petitioner has done is that they are trying to dictate the police by a letter asking the police to close the investigation, And Lordship, we have issued to 4 people. This is Ramesh Bansal, Sudipta Bhowal, Pramod Kumar, Shri Biplab Senkupta, none has responded to the notice of 41, Your Lordship, taking advantage of the order passed by Your Lordship. In spite of the fact that they have given an undertaking that they will cooperate with investigation.
We will cooperate with the investigation. My only prayer is, my Lordship,
because
appearance through online, because online, only for this bailable section, my Lord, my directors will have to come all the way from Calcutta.
Lordship, it appears from the investigation, Your Lordship, even the bill at page 67, 86, 87, 91, 92 of this, which are part and parcel of this, appear to be not genuine, Your Lordship. So these will have to be looked by the investigating officer, Your Lordship. Until and unless they cooperate with us.
Yes, but that is the issue. In a natural course of things, you have to cooperate.
My Lord, I can place on record several letters we have submitted to them that we are elderly people undergoing treatment. Please allow us to. Allow us to appear through online method,
Lordship,
virtual method, whatever.
One of them, what is telling the police because of the prevailing situation in Northeast. What kind of prevailing situation in Northeast? Also, I don't understand, Your Lordship. Maybe the situation in Manipur.
My Lord, I don't understand why learned additional AG is so keen about this case.
No, I'm not keen.
Why police is so keen, my Lord? The crime happens in West Bengal. Bailable sections. My Lord, what is the interest of Meghalaya police to investigate this matter?
Their cooperation, Your Lordship. I just need their cooperation.
My Lord, I asked this question to myself, my Lord. If a crime happens somewhere, investigation is going on, my Lord.
Dr. Muzika, whatever the case may be, once a matter has been taken cognizance of, it has to be.
My Lord, that
it has to be pursued to the fullest.
I agree, my Lord. That is why we have.
You have to allow the police to take to take steps in due diligence. You also have to allow them to complete the investigation at their own pace. You cannot, even the court cannot dictate what the IO should do. In the course of investigation,
my only prayer, my Lord, if they want to file a reply, let them file within 1 week's time, my Lord. They are asking for 3 weeks' time, my Lord, and they are issuing notices after notices to us, my Lord. I made out a case, my Lord, the bailable sections, my Lord, only bailable 469.
We are not going to arrest them, Your Lordship. We are not going to. We just need their cooperation.
They cannot arrest. These are bailable sections. How can they arrest, my Lord? If they arrest, they have to grant bail then and there, my Lord. So it's not a question of. My Lord, these are directors of a reputed company, all India level company, my Lord. Or just for a 469 case registered in July, my Lord. If they have to travel all the way, my Lord, Lordship can balance the equity, my Lord.
That is not an excuse. That is not an excuse. Once
allow us to appear online, my Lord.
Once you have been implemented, you have to. Whether it's rightly or wrongly, this is not a stage to decide on that.
My Lord, if your Lordship hear the entire matter 482, my Lord, if they can be directed to file their SOCOS, whatever they want to file within 1 week's time, my Lord. 1 week is okay.
But if your conduct is found to be amiss,
yes, absolutely no. My Lord, I'll place on record that we have responded to each and every 41A notice that we are sick. Please allow us to 41A examination, whatever you want to do, please do it through a video conference.
But that is also, Mr. Shula, you explore that possibility. If there is a possibility of conducting the whatever inquiry, through virtual mode.
Because
nowadays everything
this is a matter relates to documentary evidence. It has to be checked and cross-checked.
Whatever document in our position.
It has to be. And then it will have to. The opinion of an expert has to be sought, Your Lordship. So online, it would be, in my humble and respectful submission, it will not be possible.
My Lord, Section 91 CRPC notice have been issued for production of document, my Lord. We will do that, my Lord. There is no problem in that. But our only difficulty we are facing is the personal appearance of directors, my Lord. All the way from Calcutta and Delhi to come.
What is Calcutta and Shillong, Mr. Dr. Musika?
My Lord,
how long will it take you to
come? Elderly people, my Lord, there is medical advice, my Lord. I can show it to Your Lordship that they will ask not to fly, my Lord. My Lord, if the offences have been serious, I will not have pleaded before Your Lordship, my Lord. My Lord, offence is 469, my Lord. It's a bailable section, my Lord.
No, that apart is that.
So, my Lord, instead of 3 weeks, 1 week time is given to them, my Lord.
Yes, Mr.
My Lord, 2 weeks, my Lord, I have no problem with it. They take 4 weeks, my Lord. But in the meantime, they should not insist as to we should come all the way, my Lord.
But you have been directed.
Explore the video conference, my Lord. Or if the police wants to go there, they'll cooperate, my lord. We are agree with that.
They should have about all those documents, your lordship, which the police had shown. So what?
My lord, I can only submit, my lord. Once a lordship goes through the material, my lord, your lordship, in my humble submission, will cause the entire proceedings.
But that remains to be seen.
But that remains to be seen, my lord. But in the interim, my lord, I am not asking for time. The respondents are asking
Interim
for time.
protection has already been given to you.
Interim is there, my lord. But they issue successive notice, my lord. 41A notice after notice for every week. That is the work that is
not
41 notice. My lord, this kind of expertise I have not seen in any other case.
It is not. It's not like that. A notice has been issued. That much only, your lordship.
Well, other cases I don't see this kind of efficiency by.
Because we have to.
But again,
Lordship.
considering the fact that if at all, considering the fact that they are elderly, considering the fact that if at all they are sick and could not travel, that has to be a consideration, because otherwise, God forbid, if anything happens on the way. So the IO should take that into consideration and
then if
devise ways and means.
If that be a lordship, then I will tell. We may ask them to be present. If we'll devise the ways and mean, then they'll have to cooperate in that.
Exactly.
In that view of the matter, they should cooperate.
There is no denying that, my lord. If they can record their statement online, my lord, any day.
Because the objective is not to cause harassment. The objective is to go into the facts of the matter and find out what is true and what is not true.
That is what I have submitted, lordship. We just need their cooperation. That much only. Nothing more, nothing less, your lordship.
We are sure
We'll cooperate, my lord. They should not force us to, my lord, to travel at this time.
Anyway, that is why he will, the Leonard AAG will take that into consideration and will advise them accordingly. Mr. Pilman Nanguri, appearing for the respondent number 2, has submitted that he may be allowed, that the respondent may be allowed to file a response to the averments made in this petition to the extent it affects the respondent number 2, and for which some time is sought for. Though there is no provision for filing of a counter affidavit in an application of this kind, however, under the circumstances, the prayer is allowed. The respondent number 2 is directed to file the said response within the next date fix. Next, the Leonard AAG has in the meantime submitted that the petitioners and its directors or official have failed to cooperate with the IO in as much as no formal response has been made to the notice issued under section 41A CRPC,
as well as 91 CRPC also,
as well as the notice under section 91 CRPC. To counter to this, the counter of the learned senior counsel for the petitioner is that all the directors involved are aged persons and are also ailing, for which they have been medically advised not to travel. considering the fact that they are stationed outside the state of Meghalaya. However, so as not to create an impasse, the petitioner and the directors or official involved have once again assured this court that they will cooperate with the investigation so as to benefit from the interim order passed by this court in that regard.
One of them is 47 years, Your Lordship. One of them is 51 years.
Oh, you said aged? I thought they are 80 years and above.
No,
Not 80, my lord.
47, one is 51, then one, the name.
No, they are not directors, my lord.
The age is not reflected, Your Lordship. These are the notice issued to them, Your Lordship.
How can you say they are aged, Mr.?
Also the papers, my lord.
Mr. Shala is feeling very old.
I'm old. I think both of us, Lordship.
47 is aged.
Of course, I'm black. I'm always black topping my.
Thing,
I'm always black topping my head, so not noticeable.
But this person is advised not to air travel. Is written there, my lord. By hand, my lord.
Because notice has been issued, Your Lordship.
Fine. Form the auto kayo. So, on aged. On medical ground, perhaps.
Medical ground.
You should be careful what you submit, because that goes on record. Earlier you said they are
around 60, my lord. Some of them are around
60 is not
yes.
The people whom we have served the notice, they are like my age, Your Lordship.
Let's not go into that.
One of them is younger than me. Lordship.
First, we have to determine age of a minor, and
whether we'll go for
now we have to determine the age of an aged
we'll
person.
go for ossification test, or we'll have constitute the board, Your Lordship.
No, who knows? As paid for by the parties. This is matter of the 2 weeks. But if they are able to travel, you should tell them to come.
I'll tell them.
There's no excuse for that.
Apply, Your
Except for, you see, if they are really unable to come due to sickness or on medical advice.
One may be. I have at least symptoms attributes to avoid air travel now. This is suffering from pulmonary chest disease, my lord.
Everyone travels nowadays. Everyone takes precaution.
But this from a
If
good
somebody
hospital, my lord.
if somebody has a heart attack in Shillong, they have to rush to Guwahati or they rush to Belor or Delhi. What do? They still have to travel.
In ICU, this ambulance.
Whatever.
Recently, Your
That
Lordship, recently that Tamil Nadu minister has been arrested by the ED. When he was, prior to that, he was fit and fine. After arrest, he...
But there is no ED crime here, my lord.
No, I'm just...
No, this is not an ED crime is coming.
I'm just...
That is the extent.
Example, Your
That is
Lordship.
the extent of shock at the mention of the word police. Everyone is afraid of police.
Example only.
Fine, thank you.
Apply, Your Lordship.
After 2 weeks.
Item number 3.
Lordship, may I please, Lordship? I pray that the matter may be taken up later, Lordship. That the matter may be taken up later, Lordship, because the SC is in court number 2, Lordship.
So at the end of the board,
Court number 2.
Mr. Sheikh, what's this matter about?
This is regarding the petitioner is challenging she's, according to her, she's been demoted, madam.
Oh, the headmistress.
Yes. That is matter, madam. Otherwise, written argument is filed already.
Then what is required?
Well, he wanted to do a hearing actually.
Hearing.
Matter may come up next week also, madam.
On premium by parties, this is matter of 1 week.
How do you oblige?
Item number 8.
Yes.
Lordship, the petitioner in the last two occasions they didn't appear, Lordship.
What is this case about?
Well, Lordship, we have filed an FIR and
You have filed a FIR.
yes, Your Lordship, and they have come here for question, Lordship.
Under what section?
406, 418 and 420, Lordship, of IPC.
When this when this matter was when this matter was taken up on 21/4/2023, a counsel had appeared on behalf of the petitioner. Since then, after 3 consecutive dates fixed by this court as far as this case is concerned, none has appeared on behalf of the petitioner. And even today, the petitioner is unrepresented. Be that as it may, for ends of justice, once again, the court would allow the petitioner to be represented, failing which necessary orders shall be passed. This is matter to 2 weeks.
Still, I'm appearing. Still.
Fine.
Item number 9.
Yes, Mr. Suna, what is the progress?
Well, the talk of settlements is going on, pilot.
It's going on, but
Pilot, yes.
how long?
Yes, pilot, because to some part one person agreed, to another part don't agree.
This is a vast tract of land.
What is involved here?
They say it's a clan land. Because what the issue before this court also, Your Lordship, is that at the time when the suit was filed, it has to be endorsed by the judge. Okay. So at the time when the appeal was filed against the injunction, which was granted by the trial court, the learned judge has expressed his opinion that he cannot take up because he has recused from the matter. Thereafter, it was endorsed to the additional judge. It was pending before the additional judge for quite some time. And finally, it was heard. No, finally, it was never heard because of the COVID and all. Then there were some application files which was behind our back without our knowledge. Some application was filed before the judge for taking up the matter. Then suddenly the impugned order came out. It was against us. So against that, we have come before this court. Actually, Your Lordship, the matter can be remanded back to the additional judge. Let him heard the matter. If there's any settlement, we can settle before the trial court also.
Can we adjourn for the day? Seek instruction.
Because once he has recused, he cannot take up the matter.
How can he? So after he has recused, he took up the matter.
After he has recused again,
and passed
he
the
took up
impugn
the
order.
matter, and then passed the impugn order.
Excuse me.
Since notice was issued to the other side also.
Whatever the case may be, even if they had appeared, if the judge has recused,
We would have raised an objection.
if the judge has recused, I mean, it would not be proper for to take up the same. That by itself would be a disqualification.
So what I'm submitting is that if the matter be remanded back to the additional judge, if there's any settlement, we'll settle before the trial court.
It would be better to settle the matter,
Rather than keep the matter pending also.
On the next date matter.
On pre-made by the respondent, this matter after 1 week. So you try to seek instruction.
I'll take my instructions also. Right.
Item number 11.
2 weeks, no?
2 weeks. But you said one. It will be after 2 weeks, my lord.
Huh?
After 2 weeks.
Yeah, 2 weeks, Lord.
2 weeks.
Right.
My lord.
Yes.
My lord, I am
Yes,
appearing
Mr.
on
Raman,
behalf of the
tell me.
Yes. My lord, on the last occasion, the informant wished to appear in person before the court.
My lord, there is the private respondent, there is the complainant in the case.
Okay.
So
The informant.
Yes. You have made him a party here.
yes.
Has notice been issued?
Also yes.
Ma'am, yes, my lord. Notice has been issued. They have received. They have filed their appearance.
They have filed? Who? They have entered appearance?
No, as of now, no.
The respondent has filed their appearance. Private respondent is appearing through online.
Who's the
Yes, Lordship.
Okay, I don't know that.
Yes, Lordship. I am on behalf of the private respondent number 4. On the last occasion, Lordship directed the petitioner to charge the copy upon us, and meanwhile we have just received all the copies.
Okay.
But meanwhile, the private respondent number being old and informed person, aged over 80 years, so he couldn't just appear today. So kindly just allows us further time to appear before this lauded court, and just please the lauded court.
Mr. Banerjee, if you are appearing on his behalf, why would he appear?
Absolutely.
No, Lordship, yes, on the last occasion, I just prayed before the Lordship to appear. Before the Lauded court on behalf of the respondent number 4, that he would just appear in person as he just instructed me. But further, no instructions has been just taken on his behalf. So kindly just allows us further time to take the instructions and just appears before this Lord.
It is not necessary for him to appear in person. If he is represented by a counsel, that's elementary.
Yes.
So if you are appearing on his behalf, then we'll fix the matter for hearing.
Yes. Actually, I just prayed. I was just instructed. That's it.
So matter can be heard finally then. On pre-made by the.
But presently in this case, no reply has been.
Just one.
Lordship, kindly just allow us for the time so that we can just appear before this court, whether virtually or in person.
That is, date will be fixed, of course. Mr. Raman, you were saying something?
My lord, presently in this case, no reply has been filed on behalf of the opposite side. If they wish to file any reply, if they wish to file any.
Not necessary. Records will speak for themselves. The court will go through the records and hear your argument. So how long will fix it? 3 weeks?
My lord, yes, my lord.
Then a counsel for the respondent 4 has submitted that the respondent 4, though has instructed the counsel that he may appear personally. However, no specific instruction has been received as to whether he wishes to appear personally before this court. Be that as it may, since the respondent 4 is duly represented by a counsel, this court will hear the argument of the parties through their counsel. Accordingly, as prayed for, list this matter after 3 weeks. So 3 weeks then.
Grateful, Lordship. Grateful.
Item number 12.
So this is that criminal petition where I'm challenging the sanction given by the registrar. Well, the contention of the other side is that the sanction is not faulty because the registrar is only signed, but the sanction was given by the executive council. Well, my case is, I have a very limited argument here, my lord. My argument here is that sanction for prosecution has to be granted by the appointing authority, and before granting prosecution sanction, materials have to be produced, application of mind has to be done. So that power can never be delegated. For any other correspondence, of course, the registrar is the competent person in the university to sign documents. But when it comes to a prosecution sanction, that cannot be done. So which will amount to no sanction at all in the eyes of law.
Would sanction be the would it be under the what should I say supervision of the, or rather the EC has to take care of it?
Well, according to them, the EC is the one who can only grant sanction. Yes. And for the EC, the Vice Chancellor is the competent person to sign the sanction. Now, my lord, if the contention is such that even in the appointment letter, the registrar is signed, that is a totally different issue, my lord. This sanction is provided under Section 19 of the Prevention of Corruption Act. Now, that power cannot be delegated to somebody else to sign the sanction and send it to the court. And my argument is also on the basis of this, that, my lord, the law says before granting prosecution sanction, you have to apply your mind, you have to peruse materials on record, and then come to a proper finding, and there has to be discussion on that also in the prosecution sanction. Here it is just
but you will not be privy to that.
No, I'm not, my lord. It's not a case where I have to be heard. It's nothing like that. But, my lord, what is my argument here is, my lord, what is the prosecution sanction? The reason for prosecution sanction for a government servant is such that only an employer will be able to know whether during his course of his employment this person has done something wrong or not. So initially the burden is on the employer to actually find out whether whatever has been accused of was during his discharge of his duties and whether he has done something wrong. So application of mind is very much there. So in this particular sanction, my lord, there is no application of mind. There could not have been, because the registrar has just signed a categorical sanction which has been copy pasted and signed. In other cases, it is always the VC. That is the limited case I have, my lord. He's on legs.
He's on legs. Lordship, the DSGI is on legs.
In fact, my lord, I was supposed to file my written arguments along with case laws, but I totally forgot. In fact, I could not complete the entire thing. So, my lord, next week I'll file it. Then this is the limited argument I have. I'll place the case laws.
So you do the same.
What the Supreme Court says on this matter.
While he's on legs, then we'll have to take a nap here then.
Because this is the last matter, I suppose.
On learned counsel for the petitioner has submitted that he may be allowed to file a written argument in this matter with relevant authorities referred to by the petitioner. Similarly, the prayer is allowed. The respondent may also file a written argument if so advised. But I have not heard orally.
Yes,
so you file your written argument?
Yes.
Then Dr. Muzika is here.
This is a small matter.
He wanted to file a short written argument along with authorities.
In fact, my lord, I have also argued on his behalf. Contention of my learned senior is that the prosecution is proper because according to it is the registrar who is supposed to communicate. Now that I do not I consider the fact that the registrar is always supposed to communicate when it comes to communication and letters. But prosecution sanction is something which cannot be delegated. That is the only, an application of mine has to be there. Materials have to be produced. If Lordship will see the prosecution sanction, there is no reference to anything as such. I have certain case laws which I will file with my written argument.
My Lord, I'll place two reasons, my Lord. The Honorable Supreme Court has held, my Lord, absence of sanction can be examined under 482, my Lord. But if they are claiming any irregularity in the sanction, that is a matter of trial, my Lord. Can I just place these two case laws, my Lord? They are very leading cases on this, my Lord. Before that, my Lord, I'll just point out that the sanction is already there, my Lord. That is at page 104, my Lord.
Yes.
My Lord, this is the prosecution sanction order, reference CBI case number so and so. May I just read, my Lord, a few lines of this? Whereas upon the material placed before the Executive Council, it reveals that the Central Bureau of Investigation Anti-Corruption Branch ACP has registered FIR number so and so dated 25/02/2021 against Mr. Dinesh Bhatia on the basis of source information alleging that Dr. Dinesh Bhatia, while functioning as the Associate Professor, Department of Biomedical Engineering, NEHU, Shillong, has misappropriated government fund in projects under Environmental Information System, ENVIS, sanctioned by the Ministry of Forest and Environment, Government of India, by submitting fake exaggerated food bills, boarding and lodging bills, stationery bills and taxi bills, thus causing wrongful loss to NEHU to the extent of rupees 11,60,000 and corresponding wrongful gain to himself and others. The case was investigated by the CBI and on completion of the investigation, sanctioned under Section 19 of the Prevention of Corruption Act 1988 for launching prosecution against Dinesh Bhatia, Associate Professor, Department of Biomedical Engineering, so and so. And whereas the Executive Council of Northeastern Hill University, Shillong, being the competent authority to remove Dr. Dinesh Bhatia, Associate Professor, Department of Biomedical Engineering, Shillong, from this office after full and careful examination of the documents. What they supplied, the next document is not complete, my Lord.
Actually, this is
the prevention of corruption, so and so.
This is the clear one. In fact, the copies were supplied, it was not very clear. Just have to use some, darken the.
No, I mean, this the type copy is there.
A type copy, man. I think the first line, one line is missing because this is how it was supplied. We had to darken the Xerox copy, but this
after
one line.
After careful examination of the documents and
materials against Dr. Dinesh Bhatia do hereby accord sanction under Section 19 of the Prevention of Corruption Amendment Act for the prosecution of Dr. So-and-so under Section 120B, 420, 468, 471 of the IPC and under Section 7 of PC Amendment Act for taking cognizance of the said offence by the court of competent jurisdiction. Now, signature of the competent authority, bracket, on behalf of the Executive Council. So, and it again mentions authority number so and so at page 19N. And who signs this, my Lord? J.N. Nayak, Registrar, NEHU. My Lord, Executive Council is a body, my Lord. Now, any body act, the communication as correspondence is done through an authorized person. So, decision, as Lords will see, it is the decision of the Executive Council, not of the Registrar, my Lord. Registrar is simply communicating the decision, my Lord. And this is fully in terms of the NEHU rules and acts, my Lord. I can just point out that part, my Lord. At page 29, you lots of will find it starts from page 28, my Lord. I've only given the relevant part, but this is very voluminous, my Lord, this act and regulation. So, At page 28, registrar, my lord.
Just a moment. Just,
The registrar shall be appointed by the
just a
executive.
moment. These are the statutes of the university.
It says registrar regulation 4, my lord. It says, my lord, may I read
Just a moment.
Page 28, my lord.
Page 28.
At the bottom, my lord, registrar, section 4, my lord. It will be, in fact, clause 4, my lord.
Section 4.
My lord.
Yes.
It says, my lord, the registrar shall be appointed by the executive council on the recommendation of the selection committee constituted for the purpose and shall be a whole-time salaried officer of the university. Then, my lord, it says, subsection 5, my lord. On the next page, my lord.
Yes.
The registrar shall be ex officio secretary of the executive council.
Yes.
The academic council and the board of schools, but shall not be deemed to be a member of any of these authorities. He shall be ex officio member secretary of the Nehu court also. Court is mentioned, my lord. Then it says, my lord, what shall be the duty of registrar? That's next section, my lord, subsection. Yes. It shall be the duty of the registrar. Clause A we can skip, my lord. Clause B also we can skip. Clause D, my lord. To conduct the official correspondence of the court. Court means Nehu court. Nehu, there is a court, my lord. The executive council and the academic council. So all correspondence on behalf of executive council is done by the registrar, my lord. Now here, my lord, at page 38, you also will see. Just the next page.
Yes.
This is 13, my lord. Powers and functions of executive council.
Yes.
13, subsection 1. The executive council shall have the management and administration of the revenue and property of the university and the conduct of all administrative affairs of the university not otherwise provided for. Then subsection 2, clause to create teaching and academic post, my lord. Then it talks about clause 2, my lord. To appoint such professors, let's just got it, subsection, subclause 2, my lord, readers, lecturers and other academic staff as may be necessary, and principal of colleges and institutions maintained by the university on the recommendation of the selection committee constituted for the purpose and to fill up the temporary vacancies therein. Then on the next page, my lord, subclause 5, to regulate and enforce discipline among employees in accordance with the statutes and ordinances. So, my lord, the executive council of university is the appointing authority as well as disciplinary authority, my lord. Now, the PC Act says, my lord, the prosecution sanction has to be granted by the appointing authority, my lord. So, in my, what I understand that they are not disputing that executive council is the sanctioning authority, who is the competent authority to grant the sanction, my lord.
That we are not disputing.
Not disputing, my lord. So, the question boils down, as per their pleading, is that registrar is not the, they take a plea that the sanction has been accorded by registrar and the competent authority is executive council. Lordship has seen in my humble submission the decision is of executive council, my lord, not of registrar. Because executive council is a inanimate, is a body, my lord. They cannot communicate, they have to communicate through some human being, my lord. Moreover, my lord, so my lord, the sanction exists, my lord. As I pointed out, the sanction is there. Now the question is, they are challenging the validity of sanction, my lord, or irregularity of sanction. Now these two decisions, my lord, which I have placed. In 2012, volume 1, my lord.
Yes.
This is Dinesh Kumar versus Chairman of Airport Authority of India. The relevant para 9, my lord.
Yes.
It says, my lord, while drawing a distinction between the absence of sanction and invalidity of the sanction, this court in Prakash Singh Badal expressed in no uncertain terms that the question of absence of sanction could be raised at the inception and threshold by an aggrieved person. However, where sanction order exists but its legality and validity is put in question, such issue has to be raised in the course of trial. Of course, Prakash Singh Badal, this court referred to invalidity of sanction on account of non-application of mind. So this is the point, my lord. And in the next decision, my lord, at para 11, my lord, this is Central Bureau of Investigation versus Pramila Virender.
What is this citation?
This is 2020, volume 17, SCC 664.
Para
11.
Yes.
Further, the issue relating to validity of the sanction for prosecution could have been considered only during trial, since essentially the conclusion reached by the High Court is with regard to defective sanction, since according to the High Court, the procedure of providing opportunity for explanation was not followed, which will result in sanction being defective. In that regard, the decision in Dinesh Kumar versus Airport Authority of India, which I referred earlier, my lord, relied upon by the learned Additional Solicitor General, would be relevant, since it is held therein that there is a distinction between the absence of sanction and the alleged invalidity on account of non-application of mind. The absence of sanction no doubt can be agitated at the threshold, but the invalidity of the sanction is to be raised during the trial. In the instant facts, admittedly, there is a sanction, though the accused seeks to pick holes in the manner the sanction has been granted and claim that the same is defective, which is a matter to be considered in the trial. So in my humble submission, my lord, a sanction exists. There, if they want to challenge the validity of that sanction, my lord, on the ground of non-application of mind or any other ground, my lord, or the registrar is not the competent authority, so those they have to raise before in the course of the trial, my lord. This is not a subject matter for quashing at the threshold, my lord. My humble submission.
Excuse me.
Well, the relevant rules read out by learned senior. But, I will take lordship to page 29 of the rules.
You see, Mr. Gautam,
My lord.
in the light of these authorities cited, your defense is very limited.
I have two aspects, my lord, here.
Firstly, you do not dispute that the sanction has been issued.
Sanction has been issued by somebody who's
by
not
somebody who's
authorized.
not here, so
we can look at it in two ways, my lord. Either we say that the sanction which has been issued by a person who could not have issued the sanction, because as per the rules, my lord, I'll take you to the relevant rules.
So that would invalidate the sanction,
We can look at it two ways, my lord. Either we say there is no sanction, or either we say it's a defective sanction. Now, defective sanction stands on a totally different footing, my lord. It's a totally different footing. These two judgments, of course, my lord, I've gone through these judgments. I've done my research on prosecution sanction as well. There are a lot of judgments in this regard, my lord. Here, courts have said that, my lord, prosecution sanction can only be granted after proper application of mind has been made. My lord, an executive council has to take a decision. A resolution should be there. My lord, in fact, what my learned senior is saying is correct also. It can be challenged at the time of trial if I say the sanction is defective. But here what has happened, my lord, by passing the impugn order, in the impugn order, a categorical mention has been made that the sanction is not defective at all. So my bracket for challenging that during trial is totally closed. The only option I have is to come before this Honorable High Court, my lord. And my lord, if I take lordship to page 29 of the relevant rules placed by my learned senior. Page 29, my lord.
Page
29, my lord.
29.
That compilation given by learned senior.
Yes.
I am reading 4A, my lord.
Yes.
The registrar shall have power to take disciplinary action against such of the employees, excluding teachers and academic staff, as may be specified in the orders of the Executive Council. Now, my lord, I am a professor, my lord. I belong to the teaching staff.
Yes.
He does not have any power to take any disciplinary action against me. Similarly, my lord, even if he is the voice of the executive council, my lord, he's somebody. My learned friend has also said that somebody has to represent the executive council. Now, my lord, there are 2 cases pending against this individual. There are 2 prosecution sanctions are there. My lord, I have also enclosed another prosecution sanction granted in another case. I'll take lordship to page 107 of my petition, my lord. (107), my lord.
Yes.
I will just show you the, on page number 108, the signature in this particular sanction is signed by the Vice Chancellor on behalf of the Executive Council. So the contention of my learned friend that a person has to be there to sign the prosecution sanction is not correct, because in all other cases it is always the Vice Chancellor. In fact, in other universities also, my lord. In fact, there are certain cases where it has been challenged that even the Vice Chancellor is not the competent authority. But here, my lord, I do not dispute the fact that the Vice Chancellor can sign the prosecution sanction. So here, my lord, if this contention is taken, that it is only the registrar who can sign, then, my lord, it falls flat, because in the very next page it is very clear that in an earlier occasion it is the Vice Chancellor who has signed. So when the decision-making process was done by the Executive Council, headed by the Vice Chancellor, there is no question about the reason why the Vice Chancellor would not sign the prosecution sanction. I am saying, though, there is no sanction because no materials were produced, no application of mine was there. There is no resolution at all. It is just a categorical prosecution sanction which has been copied perhaps from other sanctions and signed by the registrar, my lord, just to serve the purpose of giving a sanction to prosecute against this employee. That is my case, my lord. So, well, as far as authorities and a written argument is concerned, my lord, my learned friend is placed 2 authorities. Allow me to place certain authorities as well with some bullet points of my argument, my lord. Lordship has understood the gist of the case, a very limited argument I have.
My lord, it is something like this, my lord. A decision has been taken, for example, we take example of this honorable court, my lord. If the registrar can communicate something on behalf of this honorable court, my lord, joint registrar can also communicate. So, my lord, in our case is that even Vice Chancellor, it's simply a matter of communication, my lord. The decision has been taken by the Executive Council and it is a question of communication. He says that under the authority of the Executive Council, I am communicating that. So, my lord, he is only a messenger, man.
Yes, you have your records with you.
We can place the record.
You place the record
because I am appearing for CBI, my lord.
Oh, CBI. Then who? Somebody has to appear for the.
No,
because the records then now is required. Under what circumstances this order was passed? Is it pursuant to? Is it pursuant to a resolution? Which should be?
It should be.
But in my humble submission, my lord, going by the law laid down, my lord, let the trial court examine that.
The only anxiety here is, my lord, trial court has already put a seal saying that sanction is proper.
That in my humble submission, that much observation can be given that this question is left open to decide whether in the trial.
That of course, this court may not go too deep into that.
My lord, we'll place short written argument with
you file your clause. If required, then necessary orders will be passed.
My lord.
If required, the new can be implemented. I have no
criminal
problem.
petition implementing new.
Yes,
that is another thing. I'll have to look into. Let's look into the possibility of implementing.
Who is the complainant?
A complainant, it's always source information. CBI has a lot of sources.
So on the source information, there must be something in writing.
It has to be reduced.
Which would serve as a complaint. Thereupon, you see, investigation will be launched.
CBI is investigated, my lord.
How do you do it?
New is never the complainant. But they can, in fact, my lord, by learned senior can call for
offences on any information. We can take the cognizance, my lord.
You can do that.
And then CBI registered the FIR, my lord, and he started investigation.
In CBI cases or under PC Act, more often than not, they do that. That is the system. But whether that is the proper form or not, anyway, that may not be relevant. If so required.
So I'll file my bullet points also. I'll include this.
So 1 week?
1 week, my lord.
But there are counsel to the parties. On the conclusion of the argument, parties have submitted that they may be allowed to file short synopsis of their written argument, their argument in written form, along with relevant authorities relied upon. As prayed for, this is matter to 1 week.
Much okay.
Much.